Hey everybody, Mark Dawes here, and today I want to talk to you about something called the Law of Unintended Consequences. Now, I learned about this when I interviewed a very eminent guy, a guy called Professor of Law Gary Slapper, who at the time was head of law for the Open University. And I interviewed Gary, and we produced a video series on all of the law in relation to the use of force for self-defense and restraint. I did an audio interview with him, and I've got this great resource actually sitting on my laptop at the moment. I never released it actually, because Gary sadly died in December 2016. So I didn't think it was appropriate to do it. But, one of the things that's recently struck me, having read through all the stuff, is Gary himself was very committed to making the law, accessible to everyone, lay members of the public, everyone. So I've decided to relaunch the whole thing. I'm just updating it all now. So this will all become available to you in due course. But one of the things I spoke to Gary about was, companies that provide staff with training, or in some cases actually they don't, but if they did provide staff with training, that training would be so low level that there was no chance that the staff would actually ever hurt anyone. So the company would have no risk. So in other words, companies are so concerned about teaching their staff how to use force that they would only teach them stuff that would work at a very low level. And Gary said to me, he said, if they do that, he said it invokes the law of unintended consequences. And that means that where a company errs too far on the side of caution, there's actually more collateral damage and more collateral fallout because they've not provided staff with the appropriate training to meet the risk and protect them or protect others from higher levels of violence. And that was really interesting because so I asked him the question. I said, well, who would be liable for that? Because if something happened, someone got seriously injured or killed and that went to court, who would be liable? And he said, well, the company would be liable, of course. He said, because quite simply, he said, if they have to evidence the training they've given to staff as part of their risk assessment process, if the training doesn't adequately control the higher levels of risk, then any serious injury or death would be blamed on the company. He said, and the company would actually be found, or highly probably be found guilty of that. He said, and if someone dies, he said, then, with regards to the Corporate Manslaughter and Corporate Homicide Act, he said, whichever director was responsible for that training, he said they could be charged with gross negligence manslaughter for not providing their staff with the appropriate training. So why is all this important to you? Well, the reason is we are living in an age now where there is a lot of emphasis on trying to actually not harm anyone. And we have restraint reduction networks and restraint reduction strategies, and there's all accreditation out there that's actually, trying to say, let's use the least amount of force necessary. And I get that. Legally, you should only use the least amount of force necessary. I get that. But not to the extent that it's going to increase the risk, because it actually is a perverse dichotomy. You try and reduce risk by actually lowering the actual threshold of force that you can use. But if that doesn't control it, then, as Gary's already explained to me, the law of unintended consequences kicks in, and we have more collateral fallout, therefore more people are injured. So, in schools, many schools years ago had no restraint policies. You can't have a no restraint policy because the very fact of having a no restraint policy, you have to ask the question, why would you need a policy for something you don't do? And I've covered that on videos before. But I just wanted to share that with you because, everyone has the right under law to stay safe. And our common and statute law provides people with rights. It gives them the right to use reasonable force. And as I've said on videos before, you cannot put up a wall and bring someone into that environment and take those rights away. In fact, you have to do the opposite. You have to enhance those rights. So if someone who, and we all UK citizens have the right to use reasonable force to protect themselves and others, and all this stuff anyway. But if they come into an environment, an employed role, under a condition of contract, be that a temporary role or a voluntary role or a full-time role, it doesn't matter, and they are exposed to higher levels of violence, so they're more foreseeably likely to encounter violence than they would outside their job, then by law, the employer has to provide them with training that's suitable and sufficient, and I've done a video on that, as part of a risk assessment, and I've done a video on that, that controls the risk. And if they fail to do that, the organisation is liable. I hope that helps. Have a great weekend, and I'll speak to you soon.